Okay, this concludes Disclosures Part 2. I just want to do a quick recap of what we've covered, some important highlights. Again, in a common interest community, or HOA, the Did You Know form is an information statement that lets the buyer know certain rights they have by buying a house in an HOA, such as they have 5 days to cancel. Should they decide to cancel, that's 5 calendar days, by the way, very important. Okay. The public offering statement is going to be included if they're purchasing a new property, only a new property in an HOA. The resale package must be ordered by the seller's agent 2 days after acceptance of the contract. The HOA has 10 days to put it together, the HOA management company. Then once the seller's agent receives it, he has 1 day to get it to the buyer's agent. Now, the buyer then has 5 calendar days, again, starting the day after they've received it, to approve those documents. Okay? And if they don't get it within 15 days of acceptance of the contract completely, the buyer has a right to cancel with no penalty if they so desire. On resale package also, the resale package must be provided from the seller to the buyer and must be paid for by the seller if there is a fee for it. Transfer fees, a statement of all the transfer fees, any unpaid obligations must be given from the seller to the buyer. That's usually going to be done in the certificate in the resale package and also at the demand at the end. The statement of demand. The statement of fees and assessments in the resale package may not be relied upon. That's very important. It is necessary for any seller to purchase a statement of demand from the association. That's going to be done at the end by escrow generally, but you need to make sure it's done if the transaction goes through escrow, which in a real estate agent's world, it's going to be 99% of the time. The escrow officer is going to order the statement of demand. That's going to tell you the exact fees, dues, payoff, everything. Okay? Impact fees. The purpose of disclosure, again, is for the seller of the property to give notice to impact fees that may be imposed on the buyer. These are future SIDs, LIDs, which is Special Improvement District or Limited Improvement District. These are basically their fees to pay for the infrastructure put in. Okay? Lien for deferred taxes. If there's a lien for deferred taxes, the seller must notify the buyer of the lien. The lien must be disclosed at the time the property is sold or transferred. So ordinarily you would require that lien to be paid off in escrow or at the close of escrow. But a buyer can purchase the property with that lien on it as long as they're aware of it. Manufactured housing. You need to know that if you're buying a used manufactured housing, your buyer is buying a used manufactured housing, you as an agent must give this disclosure to them and let them know that it is not real property, it is taxed as personal property such as a car or other means of vehicles. Okay? Manufactured and mobile home parks. So if the manufactured home your client is buying is going to be in a mobile home park, they need to know that they need to be approved by the landlord or the owner of the mobile home park first. Okay? Open range disclosure. If you have a client buying a property where there's cattle roaming next to it or any other livestock, you might have to provide this open range disclosure, which must be signed by the seller and notarized. Private transfer fee obligation. If there's a private transfer fee placed on a property because the property is built or owned prior to 2011, May 20th, 2011, there may be a private transfer fee. If there is, it has to be disclosed and the buyer has to agree to it and sign off on it. Water and sewer rates. In any HOA or subdivision, more than 25 but fewer than 2,000 customers, it has to be disclosed what the water and sewer rates are going to be on a new home. Okay? It's not needed on a resale because you can just call the utility and find out what they typically are. Okay, pool safety and drowning. This disclosure is actually contained right here in the residential disclosure guide. And for clients that are buying a property with a pool, you have to give them. We've had a lot of kids that have drowned in pools, and that's why this disclosure was created, to let you know, hey, there is a danger with buying a pool, a home with a pool. All right, some miscellaneous disclosures. Some brokerages and will have an airport noise disclosure. Building and zoning codes, especially if you're buying in a new home, you may have you may be disclosed zoning to you, what the zoning is. For example, you could have a property that is horse property, or zoned for horses. Well, that's going to have to be zoned for you, okay? and you're going to have to disclose that. Any environmental hazards, if there are environmental hazards on the property, that's going to have to be disclosed. Now, if the seller says we don't know of any environmental hazards, that doesn't take away your duty as a buyer to investigate that and make sure there's none. If you found out there used to be a gas station on that property, you might want to really check into that, for example. Okay? Gaming, this only counts on new home construction. You'll get a gaming zoning disclosure telling you how close you are to different gaming zones, okay, or hotels, things like that, but only on new home. Home inspections. If your clients get an FHA loan, and even if they're not, you should have this disclosure. This form is called the 4-year protection, get a home inspection. It basically tells the client the difference between an appraisal and a home inspection. They are not the same thing, and that they should get a home inspection. On FHA insured loans, it's mandatory. Or this disclosure, I should say, is mandatory. Okay? Military activities, if there are military activities around, such as Nellis Air Force Base or certain bombing runs, things like that, we need to disclose that. Again, licensee disclosure. If you're going to represent the buyer and the seller, you need a duties owed signed first, and you need permission from the duties owed to go to the consent to act and have the consent to act signed, giving you permission to represent both sides. Road maintenance district. If you're buying a house in a road maintenance district, they have to disclose to you what the fees are for maintaining the road. Soils report on a new construction, you'll get a soils report, and you want to see this to see how expansive the soil is, for example, that they're building your house on. You don't want to buy a house on expansive soil, or your client doesn't, I'm sure. So the buyer has 20 days, by the way, to rescind the sales agreement upon receiving a soil report. So that's kind of important too. Okay, in this review, we're going to continue on with disclosures 2. We're going to discuss some definition or terms and some procedures that you need to be aware of. So first of all, we're going to talk about the seller's real property disclosure, or the SRPD. The seller, not the seller's agent, extremely important, fills out this form to convey the seller's knowledge of the condition of the property. It is not the seller's right to determine what a buyer gets to know or don't know. However, most of the questions on the form have to do with, are you aware of any problems with, say, the plumbing or the electrical or the roof? They mean currently. There are a few questions on there that have to do with previous or current issues, such as water damage or moisture condition. All right, there are also places on there to disclose CIC or HOA information. Are there bylaws available? Okay. Any yes explanations or yes markings on the form must be explained on the explanation page. Now, it is your responsibility as the seller's agent to make sure they filled it out correctly, but not help them fill it out. It is also the responsibility of the buyer's agent to make sure it's filled out correctly before the buyer signs the form. It's very important, before the buyer signs the form. Now, again, this does not take the place of a home inspection. A home inspection is much more thorough because a home inspector might find a problem with, say, the dishwasher, for example, that the homeowner didn't know about, or a problem with anything. Broken tiles on a roof is a big one. A lot of the home inspectors will see those, but the homeowner didn't even know it, okay? Because if it hasn't caused a leak, the homeowner probably has never been on their roof. It's a very good possibility. So again, don't let your clients think that the seller's real property disclosure form is in place of a home inspection. Stigmatized property. This is a property with a history that the seller is hesitant to disclose. In other words, such as a murder happened or occurred in the house, and you don't have an affirmative duty to disclose this. And why is that? Because in some states you do, but in Nevada you do not. The reason you don't is because it wasn't caused by the house. Now, if part of the ceiling in the master bedroom fell in and somebody died because of it, then you would have to disclose that. But a murder or a suicide in the house, you don't have to disclose. And if the seller tells you not to disclose it, you will not disclose it. You have a duty to obey your client, okay? Now, however, if you're asked directly about the issue and you have actual knowledge, you must answer truthfully. Again, unless the seller tells you not to disclose. So you have to be fair and honest with anybody. So if a particular potential buyer asked you, remember who you work for, but there's a possibility that you may have to disclose it if the seller doesn't care. But if the seller tells you don't disclose somebody committed suicide in my house, then you will not disclose it. Latent defect. If you become aware of a material defect that would affect a property, you cannot hide it. as a real estate agent. You must disclose it not only to your client, but also to the other side. You do not have to do an independent research on this. For example, unstable soil conditions, but must report issues that you're aware of. Again, it's not your duty to inspect the property beyond the scope of your license, such as a home inspector, an electrician, or somebody like that. But it is your job to spot what we call red flags. You know, if there's a stain on the ceiling, when you come in, and even if it looks old, you should be asking the seller about that stain and why that's there. And if the roof was fixed, because clearly it probably leaked at one time. Negligent misrepresentation, the failure to disclose material defects due to ignorance which should have been obvious, or the agent should have reasonably known. Okay, so if you don't disclose some defect that you should have probably known about because it was pretty obvious, like again, a stain on the ceiling, okay, and you can't claim I didn't know because you should have reasonably known that. So you have a duty to disclose that, even if the seller misses it. So when you look at a house, whether you're working for a buyer or a seller, make sure you really look at the house. Even representing a buyer, don't go through the house with them and see if you think they're going to like it. You should be looking for these red flags. They'll determine if they like the house or not. HIV age disclosure. As an exception to the general directive to disclose everything possible, the age status of a prior resident of a property is confidential and not to be disclosed to potential buyers. Now, I don't care what state you're in. It is completely irrelevant in HIV and AIDS issue, what state you're living in or what state you're getting a license in. This is a federal law. If somebody dies of HIV AIDS in a house, you cannot disclose that information, period. If somebody says, I heard in a house that somebody dies of HIV, you have to say to them something to the effect that I cannot discuss these issues. It's confidential information, okay? But you cannot disclose this. You need to be very careful about this. It's pretty rare, but you need to be very careful. Okay, so what is puffing? It sounds like a funny term, but in reality, it's extravagant claims made by the seller in order to attract buyers. Well, it's not only the sellers, it's also real estate agents. You see it in listings all the time. This beautiful view of a house. Okay, well, that's somebody's opinion on the view. It might be a view of the mountains. It might be a view of nothing. So, but puffing is allowed by law, okay, but not misrepresentation. So you need to be careful about that. All right, thank you for watching Disclosures 2. Just in closing, I want to make sure that you understand you need to download from the Real Estate Division website, which is red.nv.gov. realestatedivision.nv.gov. Go there and download the Residential Disclosure Guide. The latest version is on there, which this is July of 2017. This disclosure guide explains all the disclosures that we have officially by the state of Nevada. Of course, your brokerage eventually will have other disclosures, but these are all the ones that you could be tested on and you need to know. It gives the explanation of every disclosure, when to use the disclosure, and what it's for, okay? So please, again, download this disclosure guide at realestatedivision.nv.gov. That's red.nv.gov. And it's a great study resource material. And again, download all the slides and attachments so you have that study material with you too.